HR professionals. We are still in Sevierville here at the Wimberly Lawson 40th annual Employment Law Conference update. Amazing. Hey, Joe.
Hi, how are you?
I am great. Joe Lynch is here with us this morning, and he's going to give us an update on Tennessee comp law. And he tells me there's not been many changes, but that's a good thing.
It is a good thing. It's been a heavy 4 years after workers' comp reform, and it's nice to have a bit of a year off from legislation. So.
That's right. Of course, legislation's kind of come to a halt anyway right now.
It has, yeah, a little bit.
A little bit, yeah. But we're talking about Tennessee legislation.
Right, yeah. We had, of course, the workers' comp reform came about in July of 2014, and after that, each subsequent year has been sort of a correction year where the courts have gone back and the new court system has tried to tweak the new system, add things, fix things that they sort of forgot or left out of the law. And it's been very busy as a result. And this year, the legislature has been pretty quiet. So really the most interesting things we're going to be talking about at this 40th anniversary conference are some of the case law developments that have happened.
Oh, you want to share one with us?
Sure. Yeah. I'll throw out Rhodes versus Amazon. You may have heard of Amazon, the company.
Maybe.
Yeah. Well, they had an employee at Amazon get hurt. Mr. Rhodes was working and hurt his foot and went to a primary care doctor. And Amazon had a relationship with the primary care doctor, which a lot of employers in Tennessee have, which is they say, well, okay, primary care doctor, if you're going to make a referral to a specialist, we would prefer that you send this employee to Dr. XYZ. In this case, it was Dr. Ricky Hutchison, a osteopath down in Cleveland, Tennessee.
Oh, okay.
So what happened is the employee didn't like that. There's a rule in Tennessee that within 3 days of a referral being made, a specific referral, that doctor becomes the authorized treating physician. Well, the employee complained about that and said, no, I want to go to another doctor. I think I should have a right to a panel instead of that doctor automatically becoming the treating physician.
Oh.
By the way, Amazon manipulated this because they come in and they tell my original doctor to make the referral to this doctor, and that's not fair. I should have some element of choice in my doctor. Okay?
Was he right?
He was not.
Oh.
But there was an interesting impact. So what the court decided ultimately is that became the automatic doctor, and that was fine because that's what the statute says. That the employer has a right within 3 days to either give a panel or just allow that doctor to become the ATP.
Uh-huh.
But the real takeaway from this case was that referral meant that Dr. Ricky Hutchison was not considered an authorized treating physician under the law. An authorized treating physician under the law is a doctor that is chosen from a panel. And because the natural timing of the 3 days led to Dr. Hutchison being the treating doctor, he's not an authorized treating doctor. And why that's relevant is that he loses presumptions of correctness on impairment, on causation, on medical necessity. So if Dr. Hutchison says something favorable on those topics, he no longer has a presumption of correctness and can be rebutted, which is a really bad thing. You lose control of the medical treatment as the employer, which is exactly what Amazon was trying to do. And exactly what we've actually been recommending to our clients for the last couple of years is get in there, get a relationship with the doctor, and have him, make a specific referral. So employers are certainly allowed to do that. They're allowed to go in and influence the referral doctor if they want to with the primary care physician, but they have to be careful because they may lose that presumption of correctness. So it's a practice that my clients are probably going to stop doing, frankly.
Wow, good. So what is your tip for HR professionals?
Well, tip for HR folks would be some have never really done this, and panels are really important from the HR profession because a lot of HR people, if they're not directly related, they have somebody they work with that provides these panels.
Mm-hmm.
And you really have to understand why the panels are important and how to do them properly. There's about 17 or 18 little rules when you do a panel form that you can mess up and lose control of the authorized treating physician. So that would be something where you would want to consult with defense counsel, for example, and have them walk you through the panel process so that you can make sure that you're doing it right at the employer level. Sometimes they give that duty up to their insurance carrier, but a lot of times the HR people are responsible for that, or the safety folks.
Yeah.
And they really need to pay attention because it looks like a simple form, but it is furthest from the truth that it's simple. So
it sounds complicated to me.
Yes. Yeah. So beware.
Beware. And if you need assistance with this, you can contact Joe at Wimberly Lawson. You want to give your email address?
Sure. It's J Lynch, that's JLYNCH @WimberlyLawson.com.
Very good.
Mhm.
So thanks you all for joining us, and we'll be back shortly with another interview from the 40th Annual Wimberly Lawson Employment Law Conference update. So hang in there.